Well, get this. The trial of the man that tried to assassinate President Trump just got an indefinite delay. Why? Well, prosecutors say they've uncovered a mountain, a trove of new evidence, a treasure trove of new evidence. They say makes this case, quote, quite complex. I've never heard this before. And overnight also, U.S. District Court for the D.C. for Washington, D.C. unsealed Jack Smith's 165-page filing against President Trump. President Trump overnight called this election interference. How dare you do this just 33 days until an election? So two big decisions by two judges that are raising a lot of eyebrows today. So we thought we'd ask our friend Judge Andrew Napolitano, host of Judging Freedom, all about this. There's no one I would rather ask about this. Judge, great to see you. Welcome to the show.
Thank you, Clayton. Thank you for the kind introduction. Always a pleasure to be with you.
Always great to see you. First, I guess let's start with the assassin. And this, to me, seemed like a stunning revelation from prosecutors that they've uncovered not just a little bit of evidence, but a treasure trove of evidence. And now they say it makes it too complex to move forward with a trial. Why would a judge allow that to happen? Can you walk me through that decision?
Sure. We start with the Constitution that guarantees a speedy trial. Then we proceed to a federal statute that says the trial must, if the defendant demands it, must take place within 90 days of indictment. He's already been indicted, so the clock is ticking. I don't know what the judge will do if the defense says we're ready and the government says it's not, because it is almost always the other way around. The government is ready and the defendant is not. I suspect that the defense uncovered evidence in two areas. We don't know exactly what it is, but this is just a suspicion on the basis of my experience with these things. One is prior bad acts. In the federal system, the government can tell the jury prior bad behavior, uncharged behavior of the defendant that shows a pattern consistent with what the government claims the defendant did in this case. So they probably have discovered either plotting or planning leading up to this case or other attempts by him to influence public policy by means of violence. Second area that I suspect they're delving into is in anticipation of an insanity defense. There's no real defense here to what he did. He was caught red-handed. There's no question but that he is the person that was there on the golf course. He did point the weapon out of the bushes. He did not pull the trigger. He was fired at. He ran away and they caught him. There's no question but that it's him. So his defense lawyers will say the only defense is insanity. If they use the insanity defense, the defendant does not have to prove that he's insane. Rather, the government must prove that he is sane. And in order to do that, they have to address a treasure trove of behavior on his part implicating his sanity. So in preparation for that insanity defense, they have gathered more than they expected to, and it'll take them more than 90 days to sift through it and prepare their witnesses. Will the trial judge give them more time? This is another interesting quirk. Who is the trial judge? Aileen Cannon. Does that name ring a bell? She's also the trial judge in the Mar-a-Lago documents case in which Donald Trump is the defendant. Can a judge hear two cases, one where a human being is the defendant and another where the same human being is a victim? Answer, no. She will need to remove herself from one of the two cases. So
wow.
this
Which one do you think she'll remove herself?
And curiouser, Clayton.
What would you do, Judge? What would you do? Which one would you pick to remove yourself from?
Well, I would prefer to try the documents case, but I don't think she should try it because she's so newly appointed and so inexperienced that it's been reversed so many times because of that inexperience by the Circuit Court of Appeals. But if it were I, with the experience that I had, I would want the Mar-a-Lago case. Any judge would. I don't think the Ruth case is going to go to trial. I think he'll be persuaded to plead guilty, because even if he's found, another crazy quirk, Clayton, even if he's found not guilty by reason of insanity, because he's insane. This is the John Hinckley case, who was found not guilty by reason of insanity when he tried to assassinate President Reagan. He will spend the rest of his life in a federal mental institution, or as much of his life in there as federal physicians think he should spend. Hinckley's a free man today because his lawyers and federal psychiatrists concluded he no longer suffered from whatever he was suffering from at the time he tried to kill Reagan. So Ruth is a lot older. His chances of ever being freed again are very slim, and his chances of acquittal are none and none.
One thing that came to mind, there's been a lot of suggestions about this assassin that he had connections, deep state connections. You're not in Ukraine without some sort of awareness by the CIA. You don't travel from, he published videos talking about how he's broke and that he's flying first class from Hawaii to Mar-a-Lago with flights that are, over $10,000 in flights. He had all sorts of equipment and different accessories. Did he act alone? So my mind went immediately when I saw that the prosecutors had uncovered a treasure trove of new evidence that there might be other individuals involved in this. Is that a possibility as well?
If it is under the entire controversy doctrine, which means one controversy needs to be resolved at one time and in one place, they would need to investigate these other individuals, and if they participated in criminal activity, indict them. If they did not, if they were unwitting dupes, then they're witnesses against him. So either way, it's going to take some time to develop the evidence and decide whether or not it's criminal, and if there's enough criminal evidence there of crimes, if they can prove guilt beyond a reasonable doubt. They're not supposed to just indict willy-nilly. I say not supposed to. They do it all the time. They're only supposed to indict when they honestly and objectively believe they have enough evidence to convict.
The other big story overnight is U.S. District Court in D.C. has unsealed Jack Smith's 165-page filing against Trump. Trump then last night called this election interference. And Trump warned about this yesterday. He said this was coming, that Jack Smith was going to get in the way of the election once again. What I love about you is you're always able to cut through the politics and the propaganda. So obviously we have to take what Trump says with a grain of salt. But is this election interference? I mean, on its face, that's what President Trump is alleging by unsealing this court filing. What do you make of this? And what does this court filing tell us?
The court filing, in my view, is very damaging to the former president. It's basically a roadmap of the government's case. If this case goes to trial, I say if, that would presume that Kamala Harris is elected president. If this case goes to trial, we now know what the government's opening statement will be. And the evidence of the former president's personal, private behavior, not core to the Constitution, not arguably official, but personal, private. What am I doing by putting my fingers up? The Supreme Court in the immunity case put all presidential power to three categories. Core, that which is specifically articulated in the Constitution, be the commander-in-chief of the armed forces, nominate judges and ambassadors. Official, that which statutes authorize him to do, which is core is absolutely immune. Official is presumed to be immune. And then private, personal, what he's doing for his own interest, that is not immune. So this roadmap delves into that third area, arguing that what he did on January 6th was personal, private, and not immune. So all of the interactions on January 6th that are cataloged in this 165-page document filed earlier this week are with private individuals, not with any officials in the government. And it all shows the government's theory about how Donald Trump began the day after Election Day to put together various plans and plots to interfere with the ability of the Electoral College to declare Joe Biden as the winner. Now, when Trump learned of this, he made a very interesting statement. He said, I didn't do anything wrong. They did. What did he mean by they did? he meant that the government was violating its own internal regulation about electioneering. That regulation is not a law, it's just a policy. And it says the government will not indict someone whose name is on the ballot within 60 days of election day. Of course, they indicted him long before 60 days before election day. But they did release all of their evidence. The government will say, we didn't release it, the court did. We filed it under seal because the court asked us to. The federal judge, decided to release it. Is it fair to release it? Probably not. It will become a campaign issue. Is the evidence harmful to the president? I think it's devastating.
You think it's devastating? What makes you say devastating?
Because the witnesses against him are the people in whom he confided that day. Though their names are redacted from this, we pretty much know who they are. And they testified before the first grand jury that indicted them the first time, before the immunity decision. And then they testified before the second grand jury, where the prosecutors only asked about personal private, not about core and not about official.
Does this affect the election?
You know, that's a political judgment that I usually don't make. Probably not. I think Trump's base couldn't care less what the Justice Department thinks about him. And I think Vice President Harris's base also already has such an antipathy towards Trump that they don't care what the Justice Department thinks about him.
Right. We saw new numbers out just over the past 24 hours showing that basically none of this has stuck to Trump. And the polls show that they don't care any of these motions that keep coming after him. So we will see. Judge, always great to see you. I want all of our audience, go check out, the Judge has an amazing YouTube channel. It's called Judging Freedom. If you're watching us on Rumble, it's on Rumble as well. But Judging Freedom, our friend Judge Andrew Napolitano, he's got great guests, great insight, and always great to see him. Judge, thank you so much for joining us.
It's just like the old days having these chats with you. Thank you, Clayton.
I know, I love it.
Have a great weekend.
We want to tell you about our friends over at American Financing because interest rates have finally dropped. So now is a great time to look into using your home equity in order to build some wealth. Take that not as a savings account, but as something you can use during this awful down economy. Mortgage rates now in the 4s. So now is the perfect time to consolidate your debt and reduce your monthly expenses. So if you've been living off your credit cards or not sure how to make your expenses every month and you have equity in your home, that's like a savings account that is not helping you to build wealth. So American Financing can teach you how to leverage wealth like wealthy people do. And they have been saving their customers an average of $800 a month. And they can close in just 10 days, which means that you could save yourself at least 2 mortgage payments. There's no upfront fees. You can just call them, ask some questions. It's worth learning. Right now, just call them at 866-890-8434 or head on over to americanfinancing.net/redacted. One more time, that's americanfinancing.net/redacted. Now, again, their APR for rates in the 4s, they start at about 5.672 for qualified buyers. You can find out all for yourself. Just give them a call, 866-890-8434.